everyone for coming today, and thanks to Blake Rome for doing this presentation on navigating distressed loans. I wanted to briefly introduce Kevin. Kevin O'Malley is a partner in the LA office of Blake Rome, and he concentrates his practice in financial services and commercial lending. He primarily represents commercial banks, mezzanine and second lien lenders, equity sponsors, and other institutional lenders and borrowers in asset-based and cash flow financing transactions across several industries. So I will go ahead and turn it over to Kevin. Thank you so much.
Great. Thanks, Jonathan. And thanks for having me. Appreciate it. Thanks, everyone, for joining. Hopefully, you guys will get some value out of this. And if you have any questions while I'm going through the presentation, definitely feel free to, put a question in the chat or raise your hand. I think definitely better the more interactive it is, and happy to answer any questions. Usually makes it more interesting for everybody. So interrupt me whenever you'd like. So as Jonathan said, my name is Kevin O'Malley. I'm a partner in Blake Rome's Finance, Restructuring, and Bankruptcy Practice Group. I'm one of the co-chairs of the group. For those of you that don't know, Blake Rome we're an Am Law 100 firm. We have about 16 offices throughout the country, upwards of 750 attorneys. Our finance group is about 90 some attorneys, primarily practicing in LA, New York, Philadelphia, Orange County, Chicago, Boston, Dallas, Houston. So some of the primary, hubs. We not really industry specific. We, lead transactions across many industries, automotive, cannabis, construction, energy, entertainment and media, financial services, healthcare, manufacturing, real estate, retail, intellectual property, and tech. Pretty much everything. So, anything that you can finance, we definitely have someone who can get the deal done for you for sure. Last year, I think we advised in over about 300 credit facilities in excess of about $20 billion of assets. So big breadth of experience and pretty much, like I said, across all industries and specialties. I myself primarily, work on asset-based financing, which is, lending on receivables or inventory, acquisition financing, cash flow, but primarily represent banks, some of the larger national banks. I'd say maybe 60 to 70% of the deals I do, I am on the bank side or the lender side, but also represent private equity funds, as borrowers and other companies, as borrowers in credit facilities. So I think that experience has given me, kind of allows me to see a lot of transactions from both sides. I think when you're advising a company, it's definitely beneficial to have the lender's perspective and kind of know what's going through the lender's head as you work through some of these problems, because, unless you're someone who has advised the banks or worked with the banks and really understand what the lender's mentality is, I think it's sometimes hard to figure out why they're doing what they're doing, or why they just won't lend more money, why they won't, increase their commitments. And I think it's usually a beneficial perspective to kind of know what the bank is thinking on their side of the transaction. So hopefully that'll help some of you today as we go through it. So the objectives today, kind of trying to talk about, what is a distressed loan, what's the process that, a distressed loan goes through from, maybe the first time you're in default, through continuous defaults, through, workout, forbearance agreements, and hopefully, you don't get to a point where you're considering, out of court restructurings or bankruptcies or Article 9 sales, but we'll touch on those briefly today too. So just to kind of walk you through the whole timeline of a distressed loan. Understanding the early warning signs of a distressed loan, I think lenders, have certain antennas that go up that kind of tip them off that, maybe their borrower's in trouble, or maybe there's liquidity issues or some other issues that's going on even before you really get to an event of default. So we'll kind of walk through what some of those early warning signs are to the bank, and what the lenders are looking at when they, when they think a loan might be troubled or going the wrong way. obligations of the company and the borrower to its lenders and other creditors. Do you have an obligation as, an officer, director, general counsel to notify your lender before events of default occurred, or notify them that maybe a material contract was terminated, maybe one of your suppliers can't meet their, can't supply as much inventory as you ordered. So, what are your obligations to notify the lender of things that are kind of going on inside the company, or that might be early warning signs that, might not be required by the documents, or maybe they are. Officer and director considerations and concerns. As many of you know, I'm sure officers and directors have fiduciary duties. As a company kind of creeps into, distress situation or the zone of insolvency, or then into insolvency, those fiduciary duties change, and who your constituents are change. And so, while you're a solving company, you're really working for your shareholders and your equity holders. And by the time you go into insolvency, really you're working for the lender at that point. So, who are your constituents? What other concerns do you have that usually come up in distressed loans? We'll talk about, the WARN Act later. That's a big one that, comes into play in a lot of what I do, and, representing companies and lenders in distress situations. Timeline process of a workout we'll talk about. Kind of the first steps, which is, notices of defaults, financial covenant defaults, other defaults. Usually the next step would be a forbearance agreement, kind of what the different pieces of a forbearance agreement are, and what you as a company should be looking for, and kind of what a lender expects in a forbearance agreement. Then get into restructurings, whether we're talking about out-of-court restructurings, bankruptcy restructurings, sales of the company, refinancings of the company. So all the different kind of outcomes that, might occur once you get into a distressed workout situation. And we'll talk about the strategies that lenders kind of employ when they're in those situations. Understanding the roles of certain advisors. Generally when you get into a distress situation, the lender's going to want to bring in various financial advisors. Could just be a consultant, could be an independent director, could be a chief restructuring officer, or ultimately could be an investment banker to, assist with the sale of the company, a refinancing of the company, or some other kind of liquidity event. We'll talk about bankruptcy a little bit, and other out-of-court restructurings, and some of the issues that arise with those. And then finally, what is lender liability? A lot of times when you get in these distress situations, the borrower thinks the lender is acting unreasonable, and isn't really allowing them to succeed, or is actually hampering their ability to kind of right the ship. And a lot of times you'll hear about, well, you're lender liability claims, and we're going to sue you for lender liability. So kind of understanding what lender liability is, because it's kind of an amorphous concept. There really is no kind of black and white lender liability claims. It's kind of just a hodgepodge, I guess, of different various claims that companies bring against a lender sometimes. So, so first, just some brief, quick facts about distressed loans from a lender's perspective. These are from a study from Harlan Platt at Northeastern University. Just kind of about the timeline for restructurings that banks look at. One of the first steps a bank when they have a distressed loan is, it's called a criticized risk rating, which means there's an increased risk of default. A bank usually views that as about a 6 to 10 month turnaround. If the loan is in more serious trouble, you have continuous defaults. Maybe they're not making their principal payments. You have continuous quarters of financial covenant defaults. That would be a non-accrual risk rating. And banks in those situations are sometimes looking at 27 months plus to really turn around a company, and kind of get through to where you're at a place that's good with the company, and the defaults are waived, and you're comfortable with your borrower again. I don't think we need to spend too much time on that, though. And like I said, if I have any questions, or if I say a term that someone doesn't quite understand, definitely feel free to put a question in the chat box on the side. So the first thing is, red flags from a lender's perspective. And, I think if you're on the company side, your CFO, I'm sure, recognizes these red flags as well, and your controllers, and they kind of know what's going on with the company. But from a lender's perspective, they don't always have the day-to-day knowledge of what's going on with the borrower. I mean, they're getting their interim financial reporting and their compliance certificates and things like that. But to really kind of early red flags that we look for when we advise lenders, and what the lenders are looking for is slowing AR, AR decreasing over a period of time versus historical AR, or versus industry averages, or even collections on AR. If maybe maybe the AR is constant, but the collections on the AR is dramatically decreased. That would indicate are collections being diverted, or is something else going on where there's set off rights, or customers disputing the receivables. So kind of what's going on there, where's our AR going? Second is accounts payable. Maybe the company's not buying as much inventory, or not paying other service providers, or the big one is really just stretching payables. I think that's probably the biggest red flag that from a lender's perspective that we see. I have a deal, a workout right now I'm working on, where the company essentially went from $3 million of payables to, I think we're at like 16 million just in the course of this year, and that's past due. And it's really hampering the restructuring process, because we're trying to get to a liquidity event, whether that's a restructuring or a sale of the company or a refinancing. But with that significant amount of past due payables, we're going to need someone to come in and capitalize the business. You can't just bring a lender in to refinance it without someone coming in with an equity check to really refinance the business and getting those payables current. Because if you don't get your payables current, as I'm sure many of that leads to the next kind of red flag. Did you lose a key customer or supplier relationship? Is one of your key suppliers really are they only delivering on cash on COD now? They're not giving you terms anymore. So stretching payables kinds of leads to those situations. We've also had situations, I had like a aerospace deal where essentially the borrower's sole customer was Boeing, and Boeing terminated the contract with the customer. And that's, even though we didn't have any defaults, that's kind of an immediate red flag, because okay, what's this company going to do? Where are they going to pivot to? So that's like another key red flag from a lender's perspective. Maybe your borrower's healthy, but one of its customers is having insolvency issues. Another deal, one of our borrowers' significant customers was Bed Bath & Beyond. So when Bed Bath & Beyond went into bankruptcy, it was led to a huge write-off of AR, a large quantity of inventory that wasn't being sold. So things that affect your borrower are not just related to your borrower. It could be someone else's financial issues. Delayed or inaccurate reporting. If your borrower is consistently late in delivering their financials, the projections are always off. It becomes a pattern. That's another red flag, that maybe the CFO isn't quite on top of everything. Maybe they're either intentionally being optimistic, or just not really having a handle on kind of what how to correct or how to deliver correct projections. That goes along with variances. If you're getting if your actuals come in with huge variances from your projections, that just tells you as a lender that something is off, and you really need to dig into it a little bit more. Kind of along the same vein, the inability to provide a cash forecast. We'll talk about 13-week cash flows or cash flow projections later on in the presentation, because that's one of the main tools that a lender will use to kind of gauge the viability and the liquidity of the borrower. So an inability to provide those is definitely a red flag. I had a deal once where the borrower actually couldn't even come up with an accurate, what their margins were on different projects. So they were taking on all these projects, and they literally couldn't even tell if it was profitable or not. And so that's a huge issue there. So, and then finally, the other, kind of big red flag is a financial covenant default. That's usually, the first default that will occur in these situations, unless you have some kind of, like I said, material contract termination or some other kind of event that would be an independent event of default. But generally, we're looking at, financial covenant defaults as kind of the first red flag that'll usually bring the parties to the table, and have a, start a discussion between the borrower and the lender. So then we'll go into like the timeline, kind of the process of a workout or distressed loan. I'd mentioned this before, does the company or do the officers of the company have an obligation to report a default or a potential default to their lender? It's a good question. You should look at your credit agreement, have your counsel look at your credit agreement or your loan agreement, take a look at the affirmative covenants or the reporting provisions and see if, you do have an affirmative obligation. Sometimes some of the affirmative obligations that you would have would be, a termination of a material contract, like we said, or, a significant return of inventory or some other, default on other debts. So there are certain triggers that will require you to deliver notice to your lender, and you do want to always, know kind of what those notification requirements are, because, if you do have a notification requirement that, independently would not be an event of default, but if you fail to report it, it is a technical event of default. So you do want to always make sure kind of what your reporting obligations are under your credit agreement. Another good question is, are all defaults the same? And, from a lender's perspective, and if I'm representing the lender, of course, the answer is yes. It doesn't matter if it's, late financials, late compliance certificate, or if it's a payment default. If it's an event of default, it's an event of default, and that gives me, the lender, the right under the UCC to exercise rights and remedies. It triggers all my rights and remedies under the credit agreement. And, we were, agnostic. We look at every default exactly the same. Now, practically and realistically, that's not the case. As a lawyer advising a bank client or a lender, we're not going to let a lender just accelerate because, financials were late or because there was some other technical default. Now if they start becoming, if they're late every quarter, late every month, they're incorrect. I mean, maybe that's something, but, really defaults are not the same. Most lenders are pretty cautious. They're not going to exercise remedies. They're not going to take drastic steps based on technical defaults. They might impose default interest rate, which is not, not nothing, because obviously that increased your costs and your interest costs. But really, if it's a technical default, the chances of a bank or a lender taking drastic action or some kind of extreme action are pretty slim. And, we would advise against that. So kind of one of the things too, you'll see some loan agreements, will have an MAE default. And, what's a material adverse effect? No one really knows. And, as counsel to a bank, we're very cautious. And if the only default you have and you can point to is a material adverse effect, that's not a great case. And most of the time, a lender is not going to just call a default based on an MAE. They might include it in a list of other defaults, but generally they're not going to say that, the only default is this MAE, because it just leads to all sorts of issues and really kind of pinpointing what the default is. So most lenders are hesitant to, excuse me, to call a default strictly related to that. Some of your big defaults: payment defaults, financial covenant defaults, negative covenant defaults, where, you grant liens that you weren't supposed to, you incur debt that you weren't supposed to, make dividends that you weren't supposed to. Those are some of the more material defaults that, I think a lender would have the right to exercise remedies, although most of the case, they're not going to do it right away either. So along the lines of, oh, sorry, I did not, oh yeah, I did, okay. So is there an obligation to report an impending financial covenant default? Maybe your CFO knows that you guys are going to trip your fixed charge coverage ratio or your leverage ratio. Do you have an obligation to report that to the lender before it happens? Generally, no. And I would say most of the time, no. Kind of depends on what your relationship is, I guess, with the lender. If you have a good relationship and you think this is a slight miss and, it's really just a blip. Maybe you want to just let them know or give them a heads up, but there is no obligation generally to report an impending financial covenant default until you deliver your financials and the compliance certificate. Excuse me. So kind of the first step when you do have a default and kind of in the timeline of a workout, you'll get a notice of default or a reservation of rights from your lender. These usually follow a pretty standard form, no matter who they're from. The lender might impose default rate interest. They might not. Generally, they might just reserve their right to impose default rate interest if it's the first default. They'll probably reference that most credit agreements, one of the conditions to lending is that there's no event of default continuing. So many times in the initial notice of default, the lender will highlight the fact that we have no further requirement to lend. Most of the time they are going to lend. One of the key considerations here is your credit facility a deal where the lender has cash dominion, so that all your receivables are going to a collection account or a lockbox at the lender. If they are, that is going to, make it even harder for the lender to basically cut off funds, because, they can basically strangle the company at that point, and they're not going to do that for just, an initial event of default. If they don't have cash dominion and the company has a lot of cash on the balance sheet and, a lot of cash in deposit accounts that is not being swept to a loan or anything, then, maybe the lender might not lend, or might not honor a lending request until some of the cash is used, but kind of just depends on what the situation of the loan is and how much control the lender has over your cash. One of the things the lender might do in this letter is try to implement kind of unilateral restrictions or change the credit agreement. So, a lender usually can't reduce your commitments unilaterally. They can't say, well, okay, you have a $20 million commitment, we're going to reduce it to 10. But they could say, because, we have no obligation to lend at all, we're not going to lend anything over $10 million. So effectively, while they're not amending the document, they are now putting in new conditions unilaterally that you, the company, don't have to agree to. Or they might put additional restrictions on, we're not going to lend unless you do this, X, Y, and Z. So those are things the lender can do just based on the event of default and the fact that they don't have to lend once there's an event of default. Alternatively, if it's a non-material default, the notice might just be to paper the file. It might just be to say, hey, there's an event of default, we're going to need to waive it, but we're just reserving our rights, and that's really all we're doing here. There's really no other outcome except that we're going to waive it eventually, but we do want to call the default. So some other things that the lender may require, once you have an event of default is, 13-week cash flow reports and variance reports. From a lender's perspective, they really do use the 13-week cash flow as a crucial tool in managing short-term liquidity. They usually want it on a rolling basis. So whether it's every 2 weeks, every 4 weeks, and then they're going to want variance reports. What that does is allow them to see, liquidity over the next 13 weeks. Is the company collecting what they're projecting to collect? Are they spending more than they, are saying they're spending? What are their borrowing needs going to be over the next 13 weeks? This might not be something that occurs upon the initial default, but as you get further into a workout, and you're really worried about liquidity and the lender doesn't want to increase their exposure, this is something that they really kind of lean on. And many of the times they're going to want a financial advisor or a consultant to, prepare those with the company to make sure that they're getting accurate information. If you do have a default, financial covenant defaults, this might be a time to commence discussions on a default waiver. Do you, the company, think that you're going to be back in compliance next quarter? If you do, maybe it's just as simple as, can you guys waive this default? We don't need to reset anything. We don't need to, worry about future financial covenant defaults in future quarters. We just need to waive this one and kind of keep going on as, business as usual. if something kind of major happened and the company's looking at their projections and, you're looking and you said, well, we breached the covenant this default, or that we breached the covenant this quarter, we're going to be out of compliance, next quarter. We really don't expect to be back in compliance for another, year, 18 months. That might be a time to go to your lender and say, well, hey, if we're gonna waive this default, can we maybe talk about, resetting the financial covenants based on these new projections? That is something that a lender will consider and does consider because, from an internal perspective, they don't really want, their company to be continuously in default, because then they have to go back and get waivers, and they have credit committees, and, they would almost prefer in some instances to reset the financial covenants for something that's going to be realistic and obtainable, rather than continuously having to waive defaults every quarter. Now that reset, probably comes with, fees, forbearance fees, waiver fees, amendment fees. It might come up with tightening of other restrictions in the credit agreement, but, it's something to consider to maybe, talk to your lender about, or if you're the lender, talk to your borrower about, kind of resetting the financial covenants. Alternatively, if it doesn't look like you can realistically meet a fixed charge or a leverage ratio over the next year, 18 months, maybe those covenants are replaced with new covenants, like a liquidity covenant, which, could be availability on your credit facility plus cash, or just pure availability, or sometimes, maybe just a minimum EBITDA covenant, on a rolling basis. So that, instead of kind of measuring these covenants that we know the company can't meet because of some, event or trigger, we're going to use these new covenants like minimum EBITDA, just to make sure that the company's revenue or an EBITDA are increasing, or at least meeting certain thresholds or certain minimums. And as I said, most of the time, or many times, default waiver will come with waiver fees or amendment fees. So the next thing we'll kind of talk about is after you get past the first, notice of default, if you have serious defaults or it becomes a pattern, maybe the parties will start talking about forbearance agreements. And what a forbearance agreement is the lender essentially agrees to forbear from exercising any remedies for a specified period of time, so long as the borrower is in compliance with the forbearance agreement and no other event of default under the credit agreement exists. So, many times in a forbearance agreement, this is where, you don't want to be in another event of default, so you don't want to have the old financial covenants apply. You're going to want new financial covenants. And this is where a lender may impose like an availability or a liquidity covenant, or like I said, the minimum EBITDA covenant. One of the big covenants that comes in place too in a forbearance is your cash receipts and your disbursements versus projections. The lender is going to want to make sure that you have the short-term liquidity. And what they're going to do is say, well, okay, if your cash receipts are less than 85% or 80% of what you projected, we're going to have a default, and that's going to terminate the forbearance. Or if your disbursements are more than 110, 115% of what your projections are, we're going to have another default. We're going to terminate the forbearance, because the lender wants to make sure that if things aren't going according to plan, or if things aren't going according to the budget or the cash flow projections that they received and that they're relying on, that they can essentially terminate the forbearance and start exercising remedies if they need to. So they're always trying to look for maximum flexibility in the forbearance agreement with very tight triggers that will terminate the forbearance, because the last thing a lender wants to do is give up its right to exercise remedies for 60, 90, 120 days, and then during those days have things deteriorate even further, and now they're in a worse situation than when they entered into the forbearance agreement. So they always want to put pretty tight controls in any kind of forbearance agreement. They may also require the company to engage, a financial advisor, a CRO, independent directors, or an investment banker to refinance the debt and or sell the business. If they do this, they'll usually put milestones in the forbearance agreement. So, by this date, you need to deliver an LOI that's going to, from a lender that's acceptable to us to pay off the debt. By this date, you need to deliver a term sheet. By this date, you need to, share first drafts of loan documents with us. And by this date, you need to refinance us in full. And that's another way to kind of keep the tight controls, to make sure that the forbearance will terminate, so long as, if the company's not complying with those milestones or if things are deteriorating. One important thing in a forbearance as well is that a lender will always ask for is a release. This is their opportunity to say, okay, maybe you, the company, have some claims against them that, that, they acted inappropriately or they acted in bad faith. They're going to ask you for a release in this forbearance agreement where you essentially have to waive, any prior claims. And those are usually enforceable because you're getting consideration. They're forbearing from exercising their remedies. So that's another reason why lenders really like forbearance agreements, because they get a release and can basically absolve themselves of, any claims up to the date of the forbearance. Other things they might require additional collateral or credit support. Maybe if there's a private equity sponsor or, some other, owner with deep pockets, maybe they want a capital contribution or a capital infusion. Maybe that could be in the form of debt or equity, but maybe they want some additional funds to come in, to recapitalize the business and pay some of the working capital or pay some of the payables. Maybe they ask for personal guarantees. Is there, like I said, an owner, or, maybe there's a private equity fund that'll give a limited guarantee to provide additional collateral support. And then also they might ask for additional collateral. Maybe the company owns real property that was not pledged as collateral to secure the loan when it closed. And maybe the lender's going to come back now and say, well, we need this extra collateral now since you guys are in default. So these are all kind of, tools or kind of strings the lender might pull in a forbearance agreement to get their, to shore up their situation and to get additional collateral or, try and get some accommodations from the company in exchange for their forbearance. They also may require, sales of underperforming divisions or business lines, or other cost-cutting measures. Generally, they won't specify these because this will kind of lead into lender liability issues that we might talk about later. But I have seen that on occasion, but although rare. But one thing they definitely will do is kind of cut off any leakage of cash or assets from the borrowers. So, to the extent the company was permitted to make dividends or distributions, they're going to cut those off. If there's any other kind of, subsidiaries that maybe are loan parties or affiliates that we're getting intercompany advances, they're probably going to cut those off. So they're going to want to make sure that, any cash or assets that previously might have been permitted to leave the company or leave their collateral pool are not going to do that going forward. So they're really going to tighten things up, in the forbearance agreement, and try and pull as many strings as they can. So one of the, other tools that I referenced in a forbearance agreement is they might require the company to hire a financial advisor, a chief restructuring officer, or an investment banker, or an independent director. What right do they have to impose these requirements? Generally, in the credit agreement or your loan agreement, they don't have this right. But, as consideration for them entering into the forbearance agreement, they can, basically force the company to do what they want them to do. So that's where these requirements usually come in, is in the forbearance agreement. In most instances, a lender is not going to tell the company who to hire, but they will provide a list of 3 to 5 advisors who are acceptable. Again, this all goes to lender liability concerns and the lender being too involved in kind of the operations of the company. So, whenever we do this, generally, the lender will do, here's a list of 5, CROs you can hire, go pick one, basically. So that's generally how that works. Independent directors, if the lender doesn't trust the board or the board just doesn't seem to be cooperating, they may require that an independent director be appointed, whose affirmative vote must be obtained for certain transactions, maybe to review term sheets for the refinancing or for any kind of sale of the business. Or maybe they'll require the majority of the board be made up of independent directors, or sometimes just a subcommittee. One of the restructurings I'm working on now, it was owned by a private equity company, but they were not being cooperative. So they did agree, though, to put a subcommittee of independent directors to evaluate, the offers for purchasing the company. So that's a situation where they wouldn't give up full board control to the independent directors, but they did create a subcommittee of independent directors. An independent director is someone who doesn't really have a relationship with the company, and shouldn't be part of the executive team or have any relationship to the equity owners of the company. An investment banker, if things are going south, the bank might want the company to engage an investment banker to either refinance the debt or to find a buyer. This can include a buyer in an Article 9 sale. Article 9 refers to Article 9 of the Uniform Commercial Code, which is kind of the law that governs, security interests and liens and loan transactions. And an Article 9 sale is an out-of-court sale pursuant to that. And one of the requirements is you have to run like a sale process, essentially. So, sometimes you want to get an investment banker out there to go find buyers for the business, because the last thing a lender wants to do is, sell the company in an Article 9 sale as a secured creditor and then get sued because someone says the sale wasn't commercially reasonable. And then finally, a chief restructuring officer, probably one of the most important roles that, a lender can require the company engage. The CRO generally has, broad decision-making authority. I mean, they're an officer of the company. They're appointed by the resolutions, or they're named by the resolutions. They should really be involved in the day-to-day operations of the company. They might lay off workers. They can negotiate leases, vendor, customer contracts. They're usually, reviewing the projections that are being delivered to the lender, certifying those. The lender usually wants them to be the ones that are requesting any kind of borrowings to make sure that, the borrowings are being used in accordance with the budget. They might assist the investment banker in the refinancing or sale process. And generally, they're taking any action to kind of just streamline the business, cut costs, and implement measures that improve productivity and efficiency. One thing to note is that CROs have the same fiduciary duties as other officers of the company. And if a CRO is in there, the company is more than likely in the zone of insolvency or heading towards insolvency. So part of their fiduciary duties are owed to lenders. And ignoring even the legal aspects of it, many of these CROs really get their work and their referrals, through lenders. So if you have a CRO in there, I mean, they do have fiduciary duties and they are running the business for the benefit of, the constituents, but they also are generally, friendly and work with the lenders, which is what you want, because, they do want to do a good job, and, most of the referrals do come from lenders. So just, take that with a grain of salt, I guess. So next, if you're kind of, if you're through the forbearance and, things have not turned around, the forbearance terminated and the deal wasn't refinanced, there's no buyers for the company, what are some of your options from a lender's perspective, from non-bankruptcy? There's a liquidation. You can work with the company to do an orderly liquidation. Many times, if there's a CRO in there, they can kind of run that process for you. And the reason you might do that is just, maybe there's liabilities that a buyer wouldn't want to assume. If you sold the company as a going concern, maybe the company's worth more piecemeal than it would be as a going concern. So, maybe you just want to liquidate, or maybe even the lender feels like they can get paid in full if they just do an orderly liquidation. They don't have to worry about all the costs of the bankruptcy. And if they can get paid in full, they're not necessarily concerned about what's left after they liquidate. We talked about kind of balance sheet restructurings, new debt or new equity. Those are always challenging to find when the company's in trouble. We talked about the third-party advisors that the bank is always going to want to, make sure are involved in kind of running the business for the company. And then we talked about a forbearance, which is, one of the other big tools. And then some other kind of more extreme non-bankruptcy options. You have a receivership, which is a state law remedy. This is usually used more in the context of real estate. or healthcare cases. Usually if you're an operating entity, the lender is not going to want to put a receiver in there to run the business. You'd rather have a CRO do that. They're usually more experienced, more sophisticated, and usually results in better outcomes. But if you have, real estate that doesn't really need to be operated, receivership is sometimes a good alternative. And then healthcare has some, statutory reasons why you might want to put a receiver in there. Assignment for the benefit of creditors is another non-bankruptcy, state law remedy. Essentially, the company assigns all of its assets and all of its liabilities to a trustee who winds down the company pursuant to an ABC. For a lender, this is not a great outcome. They usually don't maximize value. It's, this is usually kind of the last step in a process where, most of the assets have been sold, or, there's really nothing left to operate. You usually kind of assign everything that's left to pursuant to an ABC to kind of just shut everything down and turn the lights out, or to bury the bodies, as some of the CROs say. A note sale, this is a good exit strategy for a lender. If they can sell their note at par or even a slight discount, basically they sell it with no reps or warranties. They basically wash their hands of the note. And usually as the borrower, once you have an event of default, or sometimes, it's a subset of events of default, but generally you don't get a consent right to the assignment of the note if you're at this stage of the process. If things are going well, you do generally have a consent right. Your lender just can't sell your note. But, usually when you're at the point of a workout, we're talking about exercising remedies. They can, sell your note really without any kind of consent right from you. And then finally, Article 9 sale foreclosure. This is what I talked about a little bit earlier. So Article 9 refers to Article 9 of the UCC. The UCC is the Uniform Commercial Code, and that kind of governs secured transactions and liens and security interests, across the various states. And what this is, you, the secured lender, can sell the assets of the company free and clear of any liens to a buyer. The issue with this is, while the sale is free and clear of liens, the buyer does not get like a bankruptcy sale order. So they could be sued from creditors who are maybe not paid in full, or other creditors who try and, allege successor liability claims or something similar to the buyer. But, I think recently with the rising cost of bankruptcy, Article 9 sales do make a lot more sense in a lot of instances, for a lender at least, just because you can sell the assets free and clear. It's much cheaper. If the borrower is cooperating, it becomes even cheaper. And, maybe there's assets left for the borrower after the Article 9 sale for them to, sell, maybe get some return for equity. But generally, as bankruptcy costs have continued to go up and up, Article 9 is a good alternative. It is a very kind of precise process you need to follow. The lender needs to do lien searches, identify other secured parties and obligors, send notices to all those other interested parties. And then, you can do a public sale or a private sale. A public sale would be in the form of like an auction. So you could, rent out a room. We've done them here at the law firm. You advertise the sale in the Wall Street Journal or some other trade magazine, and you try and do a public sale. Usually those don't maximize value either. Usually the best way to maximize value is to get an investment banker and have them go out and find strategic buyers, or some other buyer through a process of reaching out to their contacts, and then you can do what's called a private sale in Article 9. But those are some of the more popular, more prevalent kind of out of court options for a lender once you get through the whole forbearance process and everything like that. Try and speed up a little bit so we have some time for questions. Bankruptcy, if some of those options don't work, bankruptcy might be a good reason to, or might be a good alternative. Some benefits of bankruptcy is it could unlock value that can't be unlocked outside of bankruptcy. If you're a retail store, maybe you have leasehold interests that are under market. Out of court, the lender can't assign those, or the buyer doesn't have a right to those. But in bankruptcy, you can assume and assign, valuable leasehold interests, or other material contracts. As long as you cure the defaults, you can assume and assign those in bankruptcy, even over the objection of the landlord. So there are some benefits there in a bankruptcy that you would not be able to do out of court. A sale of assets under Section 363 of the Bankruptcy Code. So your assets are sold free and clear of all liens and other interests, including judgments, environmental liabilities, lawsuits, employment claims, class actions, anything like that. While an Article 9 sale does also generally sell those assets free of those claims, you don't get a court order in an Article 9 sale. And many times, if there are material liabilities or obligations that a buyer wants to be sure they're not going to assume, they're going to want to do it in a 363 sale so that they get that sale order basically. The automatic stay is another benefit of a bankruptcy proceeding. Any enforcement actions that, if someone's suing you or trying to foreclose on your assets, the bankruptcy, has the automatic stay that basically stops all those actions and prohibits them from going forward. If you are going to file for bankruptcy, it's generally better to discuss with your lender, coordinate with your lender, because you're either going to need, to use their cash collateral on day one to fund your operations, or you're going to want to get some kind of financing from them or a different lender. So, rarely have I seen a surprise bankruptcy filing go well. So it is usually better to coordinate those with your lender if that is an option. Other benefits, it's, structured forum for negotiating, litigating, and resolving disputes. The big drawback is just the time and the expense. I mean, really, I don't think you can do a bankruptcy at this point for, under $1 million of legal fees or, other advisor fees. So the expense has really gotten, it keeps going up, and the more complex it comes, or the more complex it is, the more expensive it becomes. So that is, really the biggest drawback from a bankruptcy filing. Real quick, financing in bankruptcy, you'll hear what's called a DIP. What this is new financing that's provided to the debtor after filing of a bankruptcy case. Could be provided by the existing lenders or a new lender. One of the benefits of this is it's provided super priority status and takes priority over all pre-petition debt, including secured debt. It's also granted like a super priority lien over all liens that were granted before the bankruptcy. So many times the existing lender wants to provide the DIP because they can essentially get a lien that's superior to all prior liens, and they'll do what's either called a roll-up or a creeping roll-up, where some of their pre-petition debt is paid off with post-petition debt, and essentially what they're doing is now turning their pre-petition debt into super priority debt that can't really be attacked in a bankruptcy. So if you're the existing lender, you generally want to do the DIP to maintain control, kind of blesses your pre-petition liens and your pre-petition debt. Also, it's usually a good economic opportunity if there's a good exit plan. You can generally get good fees and other economics for a DIP. If the lender's not going to do a DIP, they could consent to you using cash collateral. And what that is, as proceeds of receivables or inventory come into the company, technically that's cash collateral or cash proceeds of the pre-petition collateral of the lender. And so you need their consent to use that cash. And sometimes they'll agree to that, and they might get super priority liens, to consent to that too. So, most times, like I said, you're going to want to work with your lender because they are motivated to, do a DIP or to consent to cash collateral as well, because there's benefits in it for them. From the company perspective, as you're going through these processes, some considerations, one of the big ones is the WARN Act. If you're trying to cut costs by laying off employees, the WARN Act provides that, subject to certain exceptions, you have to provide at least 60 days advance notice of any plant closing or mass layoff. Or failing that, you have to pay your employees for 60 days of back pay and benefits. Generally, an employer under the Federal WARN Act is all businesses that employ 100 or more employees. That excludes part-time employees under the Federal Act. I'll talk about the California Act in a minute, which is a little bit different. The triggers for notice would either be a plant closing or a mass layoff. So plant closing is a permanent or temporary shutdown of a site of employment resulting in employment loss in any 30-day period of 50 or more full-time employees. And then a mass layoff is a reduction in workforce other than a plant closing resulting in employment loss at a single site of at least 33% of the employees at that site or 50 full-time employees. And then who must give notice is, or who must receive the notice? You have to send it to affected employees, union representative, the state disclosed worker unit, and the chief elected official of the relevant jurisdiction. There are some exceptions to the WARN Act, although, generally you'd want to speak to your employment counsel before relying on any of these exceptions. One of them is if, you're actively seeking capital or, other, liquidity, and by giving the notice, you might hamper your ability to get that capital. That's one exception. Natural disasters or business circumstances not reasonably foreseeable. Liabilities for failure to comply, like I talked about, is 60 days of back pay and 60 days of benefits. And then note, there's no direct personal liability for directors and officers under the WARN Act. That's not in the statute, but, directors and officers have been sued for breaching their fiduciary duty to the company by causing it to violate the act. So, you still can be sued for violating it, even though it's not technically a direct claim under the WARN Act. So something to, if you are considering laying off workers or, your lenders forcing you to lay off workers, that's something that you always want to consider is the WARN Act. California has its own state statute. Oh, sorry, I forgot to flip the thing. So California has its own state statute that applies to covered establishments that employ or have employed in the prior 12 months 75 or more full and part-time employees. So California's is broader, probably not a surprise there. The Federal WARN Act only applies if over 100 full-time employees. California is 75 or more full and part-time employees. And then California applies to any plant closure affecting any amount of employees or a layoff of 50 or more employees within a 30-day period, regardless of what percent of the workforce it is. Fiduciary duties, all the directors and officers have fiduciary duties. It's important to remember that, when the company is solvent, those fiduciary duties are owed to the company with, your equity owners being the residual stakeholders. As the company moves into the zone of insolvency, which is really not a defined area, but kind of, maybe your payables are being stretched, maybe you don't have the assets to pay off all your liabilities, so you're kind of entering that zone of insolvency. It's somewhat unclear by the case law as to who the residual stakeholders are. It could be a mix of your creditors, your equity holders, but then once you're insolvent, essentially your residual stakeholders and your fiduciary duties are owed to your creditors at that point. So, if the company is insolvent, you do have a fiduciary duty to work with the lender and work with your other creditors to, hopefully assure them that they're going to be paid in full or do everything that's possible to make sure that they are paid in full. These are just some alternatives, but we'll skip over that. I guess real quick before we open it up to questions, you hear when loans go into distress situations, threats of lender liability and, what are those? Really what it is, one of the main, it's usually the legal claims are generally claims arising from a breach of the covenant of good faith and fair dealing. One of the things that triggers it is usually control. Is the lender telling you who to pay, what vendors to pay? Is the lender telling you, what officers to hire? Are they telling you what contracts to terminate? How involved is the lender in your day-to-day business? And most lenders and most counsel to lenders are going to tell them that that's the last thing you want to do. You don't want to be telling them who to pay. You don't want to be telling them who to hire. That's kind of where it evolved where, okay, here's a list of 3 to 5 advisors, hire one of them. That's why the 13-week cash flow projection and then like the variance covenants are so important, because while you don't want to tell them who to pay, you want to make sure that, you approve the budget and the 13-week cash flow and that they're not making disbursements that are, you know, out of line with that budget. So you don't want to get involved in the really nitty-gritty detail, but from an overarching high level, you do want to be involved, and you want to make sure the company's complying with their covenants that are in the forbearance agreement or the credit agreement. You know, most common causes or the borrowers allege that, you know, the lender agreed to extend the loan, they agreed they weren't going to foreclose, or they didn't lend money to pay payroll, or, you know, the big one a lot of times is, you know, you squeezed my liquidity, I couldn't buy inventory, I couldn't, you know, I couldn't turn it into receivables, and therefore the company failed. I mean, that's kind of always one of the big arguments there, is that, you know, you really squeezed us, we couldn't operate, you know, we couldn't get through this rough patch, and you effectively killed the business. Kind of one of the main claims we hear a lot of. Just some tips. These were for if you were a lender, just don't engage in day-to-day business. And yeah, I think that is it. So sorry for rushing through some of that kind of quick. But I don't know if I want to open it up to any questions. Don't see any. So I don't know, Audrey, if you had anything to close with, if there's no questions, or.
I do not see any questions. Thank you for presenting. That was very interesting.
Great. If anyone has any questions that, you know, come up after the presentation, definitely feel free to email me or, you know, reach out. Definitely happy to help or to clarify anything.
Thank you, Kevin.
Thank you. Have a good one, everyone.